302.5. This is in the rules for Supreme County Court. Index number, form, and label. Party filing first paper upon payment of fee shall obtain from county clerk an index number which shall be affixed to the paper. The party causing the first paper to be filed shall communicate in writing the county clerk's index number forthwith to all of the parties in the action. Thereafter, such number shall appear on the outside cover, first page to the right of the caption of every paper tendered for filing in the action. Each such cover and first page shall also contain an indication of the county of venue and a brief description of the nature of the paper, and where the case has been assigned to an individual judge shall contain the name of the assigned judge to the right of the caption. To the right of the caption. In addition to complying with the provisions of CPLR 2101, you have to have proof of service, and if typewritten, shall have at least double space between each line, except for quotes and names and addresses of lawyers, shall have at least 1-inch margins. In addition, every paper filed in court other than an exhibit or printed form shall contain writing on one side only, except the papers that are fastened on the side may contain writing on both sides. Oh. Papers that are stapled or bound securely shall not be rejected for filing simply because they are not bound with a backer of any kind. All papers for signature or consideration shall be presented to the clerk of the trial court in the appropriate courtroom or clerk's office, except where that clerk is unavailable or judge requests or judge directs. Papers may be submitted to judge and a hard copy filed with the clerk at the first available opportunity. All papers for any judge that are filed in the clerk's office shall promptly be delivered to the judge by the clerk. Papers shall be clearly addressed to the judge for whom they are intended and show the nature, title, and index number, judge's name, and the name of the lawyer or party submitting them. Papers filed to commence an action in a special proceeding. For purpose of CPLR 304, governing the method of commencing actions, the term clerk of the court shall mean the county clerk. Each county clerk and each chief clerk of the Supreme Court shall post prominently in the public areas of his office notice that filing of papers in order to commence an action or special proceeding must be with the county clerk. Should the county clerk, as provided in 304, designate a person other than himself to accept delivery of the papers, the posted notice shall so specify. In accordance with 2102, a county clerk and a chief clerk of Supreme Court or county clerk, as appropriate, shall refuse to accept for filing papers only under the following circumstances as otherwise provided by statute, chief administrator's rule, or other court order. 1. Paper does not have index number. The summons, complaint, petition, or judgment sought to be filed with the county clerk contains an et al. Or otherwise not a full caption. Okay, so that is a super easy question to ask because it's a list. All right, so these are the things that have to have a full caption. Summons, complaint, petition, or judgment. So there's 4 things: summons, complaint, petition, or judgment. Paper sought to be filed with county clerk is filed in the wrong court. Paper is not signed in accordance with section 130-1.1.1.A. Say that 5 times fast. Paper sought to be filed is in an action subject to electronic filing and is not being electronically filed. And it's not being filed by a pro se party who's not participating in e-filing. Or it does not include the notice required by paragraph 122.5-B of the rules. County clerk shall require payment of any fees or an order of the court waiving payment of fees before accepting a paper of filing. County clerk or chief clerk shall signify a refusal to accept a paper by use of a stamp on the paper indicating the date of the refusal and providing the reason for the refusal. So you can't just say rejects it. You have to say why. Omission or redaction of CPI. Okay, and that's in another video. So, sub E, Omission or redaction of confidential personal information. 1. Except in a matrimonial action or a proceeding in the surrogate's court or a proceeding pursuant to Article 81 of the Mental Hygiene Law or as otherwise provided by rule or court order, or whether or not and whether or not a sealing order is or has been sought, the party shall omit or redact personal confidential information in papers submitted to the court for filing. For the purpose of this rule, confidential personal information, abbreviated CPI, means 1. The taxpayer identification number of an individual or an entity, including the Social Security number, employer identification number, and an individual taxpayer identification number, except the last 4 digits thereof. 2. The individual's date of birth, except the year thereof. Replace Section 202.5E1 III, and 4. Add new I effective March 1st, 2016. Okay. 3. The full name of an individual known to be a minor except the minor's initials. 4. A financial account number, including a credit card, a debit card number, a bank account number, investment account number, insurance account number, except the last 4 digits or letters thereof. 5. Any of the documents or testimony in a matrimonial action protected by DRL 235 or evidence sealed by the court in such an action, which are attached as exhibits or referenced to in the papers filed in any other civil action. Okay. So they have to admit any of the documents or testimony in a matrimonial action protected by DRL 235 or evidence sealed by the court in such an action, which are attached as exhibits or referenced in the papers of any other civil action. For the purpose of this rule, a matrimonial action shall mean an action to annul a marriage or to declare the nullity of a void marriage, action or agreement for separation, action for divorce, action or proceeding for custody, visitation, or writ of habeas corpus, child support, maintenance, or paternity. Court sua sponte or a motion by any person may order a party to remove CPI from papers or to resubmit a paper with such information redacted, or the clerk to seal the papers or a portion thereof containing CPI in accordance with the requirements of 22 NYC-RR Section 216.1, that any sealing be no broader than necessary to protect the CPI for good cause, permit the inclusion of CPI in papers, order a party to file an unredacted copy under seal for in-camera review, or determine that information in particular action is not confidential. The court shall consider the pro se status of any party in granting relief under this provision. Where a person submitting a paper to a court for filing believes in good faith the inclusion of the full CPI described in paragraphs I and IV of paragraph 1 of the subdivision is material and necessary to adjudication of the action before the court, he may apply to the court for leave to serve and file together with a paper in which such information has been set forth in abbreviated form, a confidential affidavit or affirmation setting forth the same information in unabbreviated form, appropriately referenced to the page or pages of the paper at which the abbreviated form appears. Whatever the hell that says. 4. The redaction requirement does not apply to the last 4 digits of the relevant numbers, if any, in an account arising out of a consumer credit transaction as defined in sub F of section 105 of CPLR. In the event defendant denies responsibility for identified account, plaintiff may, without leave of court, amend his pleading to include full account number or CPI by submitting such amended paper to the court on written notice to defendant for in-camera review, or filing such full account or other CPI under seal in accordance with rules promulgated by the chief administrator of the courts, which nobody knows who the hell that even is, right? I don't know who it is. 202.5, filing by fax. In the Supreme Court, the program shall be limited to commercial claims in tax cert, conservatorship, and mental hygiene proceedings in Monroe, Westchester, New York, and Suffolk counties. Fax, and then it defines what fax means. I think we know what fax means. Okay, so then it's talking about the procedure for fax. I don't think they're going to ask this because nobody uses it anymore. Can't be more than 50 pages in length. They have to have the separate credit card or debit card authorization sheet, which is not part of the public record. It has to be kept separately by the clerk. The clerk shall not be required to accept more than 50 pages in length, including the exhibits, but excluding the cover page and the card authorization sheet. So 50 pages, including exhibits, but you don't have to count the cover page and the credit card authorization sheet. The clerk shall date stamp the papers, and when they initiate an action, the clerk shall also mark the papers with the index number. No later than the following business day, clerk shall transmit a copy of the first page of each paper containing the date of filing and, where appropriate, index number to the filing party or lawyer, either by fax or first-class mail. If the papers are ineligible, the clerk may, by telephone, fax, or postal notification, so state to the party or attorney, and the party shall forward the new or corrected page to the clerk for inclusion in the papers. So this is for technical failures. The appropriate clerk shall deem the UCS fax server subject to a technical failure on a given day if the server is unable to accept filings continuously or intermittently over the course of any period of time greater than 1 hour after 12 noon of that day. The clerk shall provide notice of such technical failures by means of the UCS fax server, which persons may telephone in order to learn the current status of the service, which appears to be down. When it's hindered by technical failure of the UCS fax server, with the exception of deadlines by law that cannot be extended, the time for filing of any paper that is delayed due to technical failures shall be extended for 1 day in which such technical failure occurs unless ordered by the court. So I'm not sure if that includes statute of limitations, but a deadline that cannot be extended, and that is a statute of limitation, cannot be extended. But I don't know. It seems kind of unfair that, if the fax is down. But then again, if you had all this time to do it, So, and I'm pretty sure that they're not going to accept, like, one of those short things like, a Article 70 or something where you only have, like, 4 months statute of limitations. They're not going to accept that by fax anyway, I don't think. So then now in this section, I recall defining electronic means, but now they have something called NYSEF. NYSCEF shall mean the New York State Courts Electronic Filing System, and the NYSEF site shall mean the New York State Courts Electronic Filing System website located at www.nycourts.gov/efile. E-filing, electronic filing, and electronically filing shall all mean the same thing. They mean the filing and service of documents in a civil action by electronic means through the NYSEF site. Unauthorized e-filing user shall mean a person who has registered to use e-filing pursuant to sub C. An action shall include a special proceeding, and an e-filed action shall mean an action in which documents are filed electronically and served in accordance with the section. Hard copy shall mean information set in paper form. Working copy shall mean a hard copy that is an exact copy of a document that has been electronically filed in accordance with this section. Party or party shall mean the party to an action or counsel thereto. Unrepresented litigant shall mean a pro se party. Expedited processing shall mean the expedited registration of a person as an authorized e-filing user. Resource center shall mean the NYSEF Resource Center. This phone number is even listed here, or at e-file at nycourts.gov and through the NYSEF site. E-filing, actions in Supreme Courts. A party may commence a filing in any county by e-filing, provided that e-filing has been authorized in that county and the class of actions includes whatever action you're suing somebody for, by electronically filing the initiating documents with the county clerk through the NYSEF site. When so authorized, a petition to commence a proceeding for review of small claims assessment and real property tax law may be e-filed, including as follows: the petition in the form described by the Chief Administrator. in accordance with this section shall be completed and signed in hard copy as provided in this section, shall be e-filed. The site shall generate and record the completed petition in proper form. Wait, what the hell? A text file containing all the information set forth and in the completed, execute a hard copy petition exclusive of the signature. Okay, so you can fill it out in a hard copy and then the site is gonna, I don't get it. Consent to the parties required after commencement of an action where e-filing is authorized. Documents may be electronically filed and served, but only by an electronic service shall be made only upon a party or parties who have consented thereto. A party's failure to consent to participation in electronic filing should not bar any other party to the action from filing documents electronically with the county clerk in the court or serving documents upon any other party who has consented to participation. A party who has not consented shall file documents with the court and county clerk and be served with documents in hard copy. When an e-filing party serves a document in hard copy on a non-participating party, the document shall bear full signatures of all signatories, and proof of service shall be filed electronically. Consent to e-filing, how obtained. No party shall be compelled, directly or indirectly, to be participating in e-filing pursuant to the section. A consent to e-filing in action shall state the party providing it agrees to the use of e-filing action and to be bound by the filing and serving provisions in the section. Party who e-filed an action shall serve upon the other parties, together with initiating documents and notice regarding availability of e-filing on a form that the chief administrator approves. Who the hell is the chief administrator? Such notice shall provide sufficient information in plain language concerning e-filing. Party who, not this. So a party who seeks to use e-filing in a pending action serves notice upon all the other parties. When such a notice is served, proof of service thereof shall be transmitted to the court. Service of such a notice shall constitute consent to e-filing an action by the party causing such service to be made. Except for an unrepresented litigant, a party with such a notice shall promptly file with the court and serve upon all the parties of record either a consent or declination of consent. An authorized e-filing user may file a consent electronically in manner provided at the NICEF site. Consent may also be obtained by stipulation. A pro se person is exempt from having to file and serve documents electronically and need not respond to the notice, except that he may consent to participate in e-filing, provided the clerk shall have first explained his or her options for e-filing in plain language, including the option for expedited processing, and inquired whether he or she would like to participate. Where an unrepresented litigant opts file consent hereunder shall be documented in the case file in a manner prescribed by guess who, that elusive chief administrator. Provided, however, that where an unrepresented litigant chooses to participate in e-filing in accordance with these rules, he or she may opt out of such participation by presenting the clerk of the court with a form so declaring. Filing of a consent to e-filing hereunder shall not constitute an appearance in the action. Documents previously filed with the court, termination or modification of e-filing procedures. When an action becomes subject to e-filing, court may direct documents previously filed in hard copy be electronically filed by the parties. Court may at any time order discontinuation of e-filing in such action or modification of e-filing procedures therein to prevent prejudice and promote substantial justice. Authorized e-filing users, passwords, and registration. Registration is required. They have to be authorized. Who may register? An attorney admitted to practice in the New York courts. Guessing, that's what it says. Say New York. Or a person seeking to serve as an authorized e-filing agent on behalf of the lawyers in an e-filed action, hereinafter filing agent, may register as an authorized e-filing user of the NICEF site. An attorney admitted pro hoc vice in an action a pro se litigant, or a person who has been authorized in writing by an owner or owners of real property to submit a petition as provided in Section 730 of the Real Property Tax Law, and who has been licensed to engage in such business and is operated herein after small claims assessment review filing agent may also register as an e-filing user. So that's like in small claims court when those people come in with a million petitions and they're basically suing to get your taxes lowered. Or I don't even know where they sue, but they sue to get your taxes lowered, and if you don't pay them, then they sue you in small claims court. So, and for them, it is solely for the purpose of the small claims assessment review filing agent, solely for those proceedings under Section 730 of Real Property Tax Law, where he has been authorized to submit a petition. How to register. Registration shall be on a form prescribed by, it is, Chief Administrator. If so provided by such administrator, registration shall not be complete until the registering person has been approved as an e-filing user. An authorized e-filing user shall shall notify the resource center immediately of any change in the information provided on his or her registration form. Can you believe that this goes on for another 2, 3, 4, 5, 6, 7, 8? Holy smokes. This goes on forever. Okay, we'll take a break and go. Okay, this is 2.5-B continued. Identification and password. Upon registration, an authorized e-filing user shall be issued a confidential user identification designation, abbreviated user ID, and a password by UCS. An authorized e-filing user shall maintain his password as confidential and his ID as confidential, except if he wants to, authorize somebody to use it. Upon learning of compromise of his user ID or password, the person shall notify the resource center immediately. At its initiative or upon request, UCS may at any time issue a new user ID or password to any authorized e-filing user. If you give your password out and authorize someone to use it, the authorized e-filing user retains full responsibility for any document filed. Electronic filing of documents. This is sub D. Electronic filing required. Format of e-file documents. Statement of authorization. In any action subject to e-filing, all documents required to be filed with the court by a party that has consented to such e-filing shall be filed electronically, except as expressly provided in this section. Documents shall be e-filed in text-searchable portable document format, PDF-A, and shall otherwise comply with the technical requirements set forth at the NICEF site. Filing agent, other than one employed by a governmental entity, shall file a statement of authorization from counsel of record in action on a form approved by the fucking chief administrator, who no one knows who that is, prior to or together with the first e-filing in that action by the agent on behalf of that counsel. Emergency exception, other hard copy filings. Documents that are required to be filed and served electronically may nevertheless be filed and served in hard copy where required by statute or by court order, where the document is an application that may by statute be presented without notice, or provided the document is accompanied by the affirmation or affidavit of the filing attorney or party stating that 1. A deadline for filing and service fixed by statute, rule, or order of the court will expire the day document is being filed and served or on the following business day. And 2. The attorney is unable to file a document electronically because of technical problems or his computer equipment or an internet connection. In the event a filer shall file and serve documents in hard copy, each document shall include the notice required by this paragraph, and the filer shall file the documents with the NICEF site within 3 business days thereafter. Form of notice required on a hard copy filing. When an action is subject to e-filing and a party or lawyer seeks to file a document in hard copy, such document shall include on a separate page affixed thereto a notice of hard copy submission in a fucking form approved by the chief administrator that the party or attorney A is authorized to and does withhold consent to e-filing, B is exempt from having to e-file, or C is authorized to or required to file a document in hard copy pursuant to an exception in these rules or another provisional law. 2. Payment of fees. When documents are filed electronically and they require a fee, they shall permit a credit card to be charged by the county clerk or in the form of information required by the county clerk to permit him to debit an account maintained by the county clerk by a lawyer or law firm appearing for a party to the action, or such information as shall be required at the NICEF site to permit an automated clearinghouse debit to be made, or any other form of payment authorized by the fucking chief administrator. Notwithstanding the foregoing, where permitted by the county clerk, finally someone else gets to approve something. An authorized e-filing user who electronically files documents that require payment of a fee may cause such fee to be paid thereafter at the office of the county clerk. When documents are filed, documents may be transmitted any time of day and night to the NICEF site. A document is filed when it's electronic transmission, or in the case of a petition that is filed by submission of a text file as provided in sub B1 of this section. The electronic transmission of the text file is recorded at that site. 3. Filing and receipt of documents notification. 1. When documents are filed, documents may be transmitted at any time of the day or night to the NICEF site. A document is filed when its electronic transmission, or in the case of a petition that is e-filed by submission of a text file as provided in subdivision B1 of this section. The electronic transmission of the text file is recorded at that site, provided, however, that when payment of fees is required, the document is not filed until transmission of the document and the information or form or information as required in 1, 2, or 3 of paragraph 2 of the subdivision has been recorded at the NICEF site. Or if no transmission of that information or form or information is recorded where permitted by the county clerk until payment is presented to the county clerk. So your shit is filed when you pay, and if there's no fee, it's filed when the text file is recorded at the site. When its electronic transmission is recorded at that site. The document is filed when the electronic transmission is recorded at the NICEF site. Okay. Or whenever you pay. Okay. Notification. No later than the close of business on the business day following the electronic filing of a document. I am not saying that fucking name again. No later than the close of business on the business day following the electronic filing of a document, a notification shall be transmitted electronically by the NICEF site to the person filing such document and all other parties participating in e-filing. When documents initiating an action are filed electronically, the county clerk shall assign an index number or filing number to the action, and that number shall be transmitted to the person filing the documents as part of the notification. If, where permitted, payment is submitted after the initiating documents have been transmitted electronically, the county clerk shall assign the number upon presentation of the payment. Official record maintenance of files, working copies. When a document has been filed electronically pursuant to this section, the official record shall be the electronic recording of the document stored by the county clerk. The county clerk or his designee may scan and e-file documents that were filed in hard copy in an action subject to e-filing, or maintain those documents in hard copy form. All documents maintained by county clerk as official electronic record shall also be filed in the NICEF system, where a document that was filed in hard copy is thereafter e-filed. The filing date, a document, let me start over there. Where a document that was filed in hard copy is thereafter e-filed, the filing date recorded in the NICEF shall be the date of the hard copy filing. That makes sense. The court may require the parties to provide working copies of the documents filed electronically. Yeah, because we love wasting paper. In such event, each working copy shall include... No, that's just so stupid! It shall include, firmly annexed thereto, a copy of a confirmation notice in a form prescribed by the fucking chief administrator. Decisions, orders, and... What a stupid law! Decisions, orders, and judgments, unless the courts direct otherwise, any document that requires a judge's signature shall also be transmitted electronically and in hard copy to the court. Unless the chief administrator authorizes the use of electronic signatures, decisions, and orders and judgments shall be signed in hard copy. All signed decisions, orders, and judgments shall be converted into electronic form and transmitted to the NICEF site by the appropriate clerk. Why? That's stupid. Exhibits and other documents in hard copy, notwithstanding any provision of the section, and subject to such guidelines as may be established by the chief administrative judge, the county clerk, or his designee, may require or permit a party to file in hard copy, in accordance with procedures set by county clerk or designee, an exhibit which is impractical or inconvenient to file electronically. Signatures. 8. Signatures. Signing of a document. An electronically filed document shall be considered to have been signed by and shall be binding upon the person identified as a signatory if 1. It bears the physical signature of such person and is scanned into an electronic format that reproduces such signature, or 2. The signatory has electronically affixed the digital image of his signature to the document, or 3. It is electronically filed under the user ID and password of that person, or in a tax cert action in which the parties have stipulated to this procedure, it is an initiating document that is electronically filed without the signature of the signatory in a form provided how that provider. Okay, so in a tax cert action, the parties stipulate to the e-filing procedure, and they file this initiating document, and it's filed without a signature, and the document is signed in full hard copy in advance, and that has to be preserved until the conclusions of all proceedings, including appeals, in the case of when an appeal is filed, and the electronic record of the document bears the word signed typed on the signature line. In a small claims assessment review proceeding, it's a petition recorded by the NICEF site upon the filing of a text file, provided that the document was signed full and hard copy, and they have to, keep it till the end of the case, including Article 78 review and appeal, and must be made available during the proceeding upon request of the respondent or the court, or it otherwise bears the electronic signature of the signatory in a format conforming to standards as may hereafter be established by the fucking chief administrator. Compliance with Part 130. A document considered to have been signed by a lawyer or party in compliance with Section 130 of the Rules of the Chief Administrator, if it has been signed by the lawyer or party as provided in paragraph 1 of this section, and it bears the signatory's name. Certification of signatures. A judge, party, or lawyer may add his signature to a SIP or other filed document by signing and filing a certification of signature for such document. Service of documents. Initiating documents may be served in hard copy pursuant to Article 3 of CPLR, or in tax cert cases pursuant to the real property tax law, and shall bear for full signatures as required thereby, or by electronic means if the party served agrees to accept that service. In the case of a proceeding to review a small claims assessment where a petition has been e-filed, A hard copy of the petition, fully completed and signed, shall be mailed, served upon the assessing unit or tax commission as provided in Section 730 of Real Property Tax Law, unless otherwise stipulated. A party served by electronic means shall, in 24 hours service, provide the serving party or lawyer with an electronic confirmation that the service has been effected. That's a little stupid, because what if he serves it on a weekend? Service of interlocutory documents in an e-filed action. Email address. Each party in an action subject to e-filing that is consented to thereto shall identify an appropriate form and email address at which service of interlocutory documents on that party may be made through notification transmitted by NICEF, hereinafter email service address. Each filing user shall promptly notify the Resource Center in the event of a change of his email address. How service is made. Where parties to an action have consented to e-filing, a party causes service of an interlocutory document made upon another party participating in e-filing by filing the document electronically. Upon receipt of an interlocutory document, the NICEF site shall automatically transmit its electronic notification to all mail service addresses in such action. So, if you file a document in the NICEF site, and the NICEF site automatically transmits the electronic notification to all mail services addresses in the action. Such notification shall provide the title of the document received and the names of those appearing on the list of email service addresses to whom that notification is being sent. Each party receiving the notification shall be responsible for assessing the NICEF site to obtain a copy of the document received, except as provided otherwise in sub H3 of the section. The electronic transmission of the notification shall constitute service of the document on the mail service addresses identified therein. However, service will not be effective if the filing party learns that it did not reach the address of the person to be served. Proof of such service will be recorded on the NICEF site. A party, however, may utilize other service methods permitted by CPLR, provided that if another method is used, you still have to file your affidavit of service electronically. Addition of parties or proposed interveners in a pending e-filed action. A party to be added shall be served with the initiating documents in hard copy, together with a notice regarding the availability of e-filing, to which response shall be made as set forth in that action. The proposed intervener or person seeking non-party who seeks relief from the court in an action subject to e-filing, if consented to e-filing, shall promptly notify and serve a consent. If an added party or intervener does not consent to e-filing, subsequent documents have to be served in a hard copy, but the action shall still continue as an e-filed action to all consenting parties. H. Entry of orders and judgments and notice of entry. Entry. Date of entry. In an action subject to e-filing, county clerk shall file orders and judgment of the court electronically, which shall constitute entry of the order or judgment. The date of entry shall be the date on which transmission of the order or judgment is recorded at the NICEF site. Notwithstanding of the foregoing, if the county clerk receives an order or judgment and places a filing stamp and date thereon reflecting that the date of receipt is the date of filing, but does not e-file the document until a later day, county clerk shall record at the NICEF site the entry of the date shown on the filing stamp. 2. Notice requesting entry of judgment. County clerk may require a party seeking entry of judgment electronically served upon the county clerk in a form specified by the county clerk a request for entry of judgment. So here is a form that is made by the county clerk. It's a form specified by the county clerk a request for entry of judgment. Notification, service of notice of entry on parties. Upon entry of an order of judgment, the NICEF site shall transmit to the email service addresses a notification of receipt of such entry, which shall not constitute service of a notice of entry by any party. A party shall serve notice of entry of an order or judgment on another party by serving a copy of the order of judgment and written notice of its entry. A party may serve the documents by filing them electronically with the NICEF site and thus causing transmission by the site of notification of receipt of the documents, which shall constitute service thereof by the filer. Either that or you could do it, the old-fashioned way in hard copy, and then you just file your affidavit of service electronically. So this is actually saying that the automatic email that goes out initially of the entry of the judgment does not constitute a notice of entry by any party. A party must serve written notice of the entry, but you could still do it electronically with the NICEF site. Then it says here, if service is made in hard copy by any method, and then proof of the hard copy service are filed with the NICEF site, transmission by the NICEF site of notification of receipt of those documents shall not constitute additional service of the notice of entry on the parties to whom the notification is sent. I think that's supposed to be not, but it's like a little typo there. It says NTO. Technical failures. The NICEF site shall be considered to be subject to technical failure on a given day if the site is unable to accept filings or provide access to filed documents continuously or intermittently over the course of any period greater than 1 hour after 12 noon of that day. So, I guess if it's malfunctioning in the morning, that's okay. But if it's, it's so weird. Notice of all such technical failures shall be provided on the site. When e-filing by electronic means is hindered by a technical failure, a party may file with the appropriate clerk and serve in hard copy. With the exception of deadlines, okay, yeah, we know that. Extend for 1 day. For each day on which such failure occurs, unless otherwise ordered by the court. In the event an attorney shall file and serve his documents in hard copy, the filer shall also file those documents. I'm guessing it's going to say filed, within 3 business days after restoration of normal operations of that site. Oh my gosh, there is a 205.BB. What? J. Electronic filing of discovery materials. In any action subject to e-filing, parties and non-parties producing materials in response to discovery demands may enter into a stip which shall be e-filed, authorizing e-filing of discovery and discovery materials to the degree and upon terms and conditions set forth in the stip. In the absence of such a stip, no party shall file electronically any such materials except in the form of excerpts, quotes, or select exhibits from such materials as part of motion papers, pleadings, or other filings with the court. K. Copyright, confidentiality, and other proprietary rights. 1. Submissions pursuant to e-filing procedures have the same copyright, confidentiality, and proprietary rights as paper documents. In an action subject to e-filing, any person may apply for an order prohibiting or restricting electronic filing in the action of specifically identified materials on the grounds that such materials are subject to copyright or other proprietary rights or trade secret or other privacy interests, and that e-filing the action is likely to result in substantial prejudice to those rights or interests. Unless otherwise permitted by the court, a motion for such an order shall not be filed less than 10 days before the materials to which the motion pertains are due to be produced or filed with the court. This is labeled 202.5-BB, but the section continues just calling itself regular -B, so we'll see. And I was really wrong about something that I assumed before. So I'll get to that. This is mandatory e-filing. Except where otherwise provided by statute, all documents filed in the Supreme Court shall be filed in the following class of cases to the extent and manner prescribed in this section. Notwithstanding the foregoing, the Chief Administrator shall not eliminate the requirement of consent to participate in electronic filing in the following classes of cases: matrimonial actions as defined by the CPLR, so not as defined by the rules regarding CPI, election law proceedings, proceedings brought pursuant to Article 78 or 70 of the CPLR. See, I thought that would be automatically like you couldn't e-file proceeding against a body or officer in Article 78. Proceedings brought pursuant to mental hygiene law, residential foreclosure actions involving a home loan as such terms defined in 1304 of Real Property Action Proceeding Law commence other than actions commenced prior to 9/1/17 in Erie, Essex, New York, Queens, Rockland, Suffolk, and Westchester counties, provided, however, that the fucking Chief Administrator may require initial filing of papers required for the commencement of such action in any county where made by a party represented by counsel be electronically filed. And 6, proceedings related to consumer credit transactions except this is in whatever. Yeah. Notwithstanding the foregoing, keyword notwithstanding, Chief Administrator shall not eliminate the consent requirement to participate in e-filing in the following classes of cases. 1, matrimonial actions as defined by the CPLR, which is important to note because the definition of a matrimonial action is different when they're talking about CPI in the civil rules. 2, election law proceedings. 3, proceedings brought pursuant to Article 70 or 78 of CPLR, so that would be proceeding against a body or officer or habeas corpus proceedings. 4, proceedings brought pursuant to the mental hygiene law. 5, residential foreclosure actions. For all actions other than actions commenced prior to 9/1/17 in Erie, Essex, New York, Queens, Rockland, Suffolk, and Westchester, provided, however, the Chief Administrator may require initial filing of papers where the party is represented by counsel be electronically filed. 6, consumer credit transactions, same deal as the first one about the 9/1/17 thing. Commencement of actions under this section. Mandatory commencement in general. Except as otherwise provided, every action authorized by sub A shall be commenced by electronically filing, initiating documents with the county clerk through the NICEF site. Emergency application. An action otherwise required to be an e-file may be commenced by initiating documents in hard copy where permitted or required by statute or court order, and may be commenced provided such documents are accompanied by affirmation or affidavit of filing attorney stating that statute of limitations will expire on the day documents are being filed or on the filing business day, and they have technical problems with their computer equipment or their internet connection, and then they have to file the documents within 3 business days thereafter. So that's how that works. For the purpose of this section, such an action shall have been deemed to have been commenced electronically. Service of initiating documents. Personal service of initiating documents upon a party that must be commenced by e-filing shall be made as provided in CPL Article 3 or the Real Property Tax Law or by electronic means if the party served agrees to accept such service. Such service shall be accompanied by the form advising the recipient that the action is subject to e-filing, and the party must within 24 hours provide the serving party or lawyer with an electronic confirmation that the service has been effected. All documents to be filed and served electronically. Except as otherwise provided in this subdivision, the filing and service of all documents in an action that has been commenced electronically with this section shall be by electronic means. Notwithstanding any provision of this section, a party to be added in an action that has been commenced electronically. Okay, so this is about a proposed intervener or a new party being joined in the action by a supplemental summons or a motion to intervene or join. So what basically this says is that they have to be served with the documents, they have to get the notice, and if they file the documents within, if they file their consent, then they can get e-filing, and if not, yada yada. A chief clerk and the county clerk may refuse to accept for filing hard copies of documents sought to be filed in actions where such documents are required to be filed electronically. A pro se person can opt out by presenting the clerk of the court with a form so declaring. Exemption of represented parties. Notwithstanding the foregoing, a lawyer or authorized representative of a property owner designated as such by the real property tax law, small claims assessment filing agent shall be exempt from having to serve e-filing documents. What the fuck does this say? You kidding me? This says that if you're one of those people that does the suits for the real property small claims assessment filing agents, you could file an affidavit with the fucking chief administrator's form saying that you certify in good faith that you lack the computer hardware connection to the internet or scanner or other device by which documents may be converted to an electronic format, or you're fucking a Luddite and you can't figure it out, and no employee or authorized representative can figure it out for you because you lack the requisite knowledge in the operation of such computers and scanners necessary to comply with this section. For the purpose of this paragraph, the knowledge of any employee of an attorney who is subject to such attorney's direction shall be imputed to the attorney or such authorized representative. Exemption of counsel showing good cause. Nothing shall prevent a judge from exempting a lawyer or other authorized representative from having to file and serve documents electronically in accordance with this section upon a showing of good cause. Applicable to exempt lawyers and small claims assessment filing agents. When they're exempted, he shall serve the documents in hard copy, provided that each document shall include the notice required by 202.5-B, paragraph 1 sub D. County clerk or the court, with approval of the fucking chief administrator, may require an exempt attorney or small claims assessment filing agent to submit an additional unbound hard copy of the documents being presented in hard copy to the court. Oh, so that you could scan it for them, maybe. The procedure applicable to e-filing lawyers and other persons. I guess this is continuation of the exempt people. In any action where a lawyer or person is exempt, all other lawyers, small claims agents, pro se parties, proposed intervenors, or others participating in e-filing and seeking relief from the court shall continue to be required to file and serve documents electronically, except when they serve the documents on the Luddite who's exempt, or the poor pro se person who has no idea what's going on. They have to serve those people in hard copy bearing full signatures and shall file the affidavit of service electronically. And hallelujah, we are finally done with 202.5 and 202.5-B and like double B if that really is applicable to exempt lawyers and small claims assessment filing agents. When they're exempted, he shall serve the documents in hard copy, provided that each document shall include the notice required by 202.5-B, paragraph 1 sub D. County clerk or the court, with approval of the fucking chief administrator, may require an exempt attorney or small claims assessment filing agent to submit an additional unbound hard copy of the documents being presented in hard copy to the court. Oh, so that you could scan it for them, maybe. The procedure applicable to e-filing lawyers and other persons. I guess this is continuation of the exempt people. in any action where a lawyer or person is exempt, all other lawyers, small claims agents, pro se parties, proposed intervenors, or others participating in e-filing and seeking relief from the court shall continue to be required to file and serve documents electronically, except when they serve the documents on the Luddite who's exempt, or the poor pro se person who has no idea what's going on. They have to serve those people in hard copy bearing full signatures and shall file the affidavit of service electronically. Finally, 202.5 is over.